Okay, so my battery went, so I had to charge it back up again just as we're doing that talk. This is the second part, but this is about the Value Added Tax Act 1994. And this is in part 2, exceptions relating to supplies made electronically supplied services. Well, this is the thing. If you've got a YouTube channel, it is an electronically supplied service, right? And just like with printed matter, in this value, when you're getting leaflets and flyers, and I've argued stickers now because it falls under the criteria, particularly because its handbills are posted in public as well to be stuck up, and obviously not perishable immediately. They got to last at least, for some amount of time. And also references to adverts. So as long as it's not a picture or an image, it's regarded as an advertisement if it's directing you to an advert or is an advert, like a website directs you to an advert, can do, or just the name of a company directing you to the company, really. But we're talking about political and charitable, not business ones. But so what they've put the same, basically essentially the same rules for electronically supplied services. Now, what I was saying in the other video, I was just about to say, is that, well, YouTube, after I started my channel, YouTube suddenly decided that just as I was looking into monetization and figuring out how to get monetized and see if my channel qualified by viewing figures and so forth, they suddenly made it so I can't monetize. And I think it was this MRR Buffnut and husband, 77th Brigade, these people that Russell Brand has been talking about, and Tucker Carlson, these kind of Tory judges, politicians, House of Lords people who don't want independent political powers, people to succeed, particularly not my one, even though it was a petition to Parliament and literally the highest protection you can get. Remember, elections and referendums are protected, but only while they're operating, and there are restrictions for those because the government, when you get an election and a referendum, the government are going to be asking everyone anyway. They're going to ask everyone on your behalf, and it's paid for by the public. So on the fairness doctrine, you've achieved the referendum or the election. So they're doing all the work for you, and it's going to be run through a uniform procedure. In order to get the law changed, or in order to get the referendum or election, which will be run on the fairness doctrine, which is to do with elections, elections are protected, but they have to be run under this fairness doctrine, under competitive rules, which is why politicians can't really be hosts on major channels, but they can have their own adverts and they can have their own broadcasts, party political broadcasts and so forth. So for petitions, you've got to collect as many signatures as possible and share it as much as possible, so you're completely protected. And as I was saying, Standing Orders 145A3 of Parliament is what subpoenas and summons powers of court to compel proceedings. Now, the proceedings of Parliament are share the material. So you've got to share it to get as many witness statements and signatures as possible. And your directions to do that are on the Petitions Committee website. Share these petitions. And they direct you to use electronic mail and platforms like Twitter, Facebook, WhatsApp. Now, electronic mail, there are many, many companies that provide electronic services to send mail. Yahoo, BT.com, Outlook, Gmail, Hotmail, and more. There are literally, 100 probably or more major electronic mail, and you have to use that. You used to be able to get free mail through Royal Mail before we sold it off privately. But those mail services are free anyway, but they've got a cap on them for you, on how many you can send a day. I now believe that if I go onto YouTube with my account, like, it's just an account, free account online electronically, like Hotmail's a free account or Gmail's a free account. Gmail's a free account. YouTube's a free account. When I go to Robert F. Kennedy's address, Robert F. Kennedy Jr.'s address on YouTube, his electronic address on YouTube, I send him an electronic message. I put him one the other day. So that's electronic mail. It's electronic mail to a person deliverable. Now, so that YouTube is electronic mail. And understanding Orders 145A of Parliament, I'm directed to use electronic mail to share the petitions and communicate about them. So, and the 145A3 powers are court powers, basically. Now, the thing is, if court want to stop people publishing things, they put this what you call like a press ban. That's one of the court powers. It falls under, making orders, but these are orders to do with information. It's an information order. Instead of compelling them to give the information, it's compelling them not to give the information. So it's like it's an information order, but it's to stop information, not force information to flow. So it's the same. It's within. So you see the Inquiries Act 2005 gives these powers to the inquiries. They can stop information, but they also have powers to compel information as well. Stop or compel informations, because the Inquiries Act can put press bans on witnesses and so forth. The Petitions Committee is above all those courts. It's Parliament, and it is 145A3 powers, which give the powers of the same as the Inquiries Act to either compel evidence or persons. Now, the thing is, when you share a petition, you are compelling the evidence to be able to publish it to the public, which is what the freedom of the press is for in the First Amendment. So everyone has a fair right for political purposes to be able to communicate, either in the post, by mail, on the telephone, or in the press for political matters of democratic function. Petition is collecting signatures is one of those functions. Now, the Petitions Committee are telling you to use YouTube. Well, they're saying use electronic mail. That's YouTube. It's electronic mail. And in fact, electronic mail, you can send a video or you can send an audio recording through electronic mail. So that's YouTube. It's electronic mail. So my channel's been unlawfully taken down. It's protected by Standing Orders 145A of Parliament, House of Commons, and additionally through the enactment of the 1688 Bill of Rights right to petition, in exactly the same way how it compels it through the Town and Country Planning Act through Class F, so you can put it up in public. So the same. Now the thing is, they're also saying here, I've talked for 8 minutes now, but I've been through all that in the other videos, but I'm just saying that this is, so the VAT, the Value Added Tax Act 1994 is treating online services under the same band as printed matter for political. So that means also that if it, YouTube can't take tax from you, VAT, for political matters. YouTube can't take VAT from you. And there's an argument for educational as well. There's an argument for educational as well. Not only educational, but religious. Religious, educational, charitable, and political. Now, the thing is, what YouTube did on the sly was they went through a lot of channels and they said, you're not eligible for monetization a number of years ago. My channel was one of the ones. And they did that sneakily, coyly, craftily, just as I'd suddenly thought, I think I might monetize my channel because I could be pretty cool to get some money in. But you know, I'd only just got quite a few videos going, and just as I started sniffing around to have a look at how to do it, they did that. I've got a feeling it was MRR Buff, Not and Husband, and 77th Brigade, and that area of what Russell Brand and Tucker Carlson have been talking about who did it. So I couldn't get any money. Now, the thing is, I don't like YouTube ads anyway. I don't like YouTube ads. I hate having to watch adverts on YouTube. I despise them. So really, I wouldn't really want people to have to watch adverts myself. I'd rather, you know, them not have to watch them, because I don't like having to watch them, and I wouldn't want to force other people to watch them. But really, I should have had a right to monetize it if I wanted to, because that money, if used, I've got the right to use that money to promote the channel more, use it all for more promotion. I don't have to keep it for profit. As long as I use that money for promo to further the aims of the campaign, it's non-profit and it's not business or commercial. Now, YouTube probably craftily, of what they've done is they've actually told everyone they can't monetize their channels, certain people like me. But yet Russell Brand, you know, he could monetize. He's classed as a press channel. Now that's crafty, because really, not only have you got a political right to be on YouTube, and actually powered by standing orders of Parliament and not be taken down, and a legal right to communicate, not just a legal right, an enforceable right. Also, you've got a right to collect money. And not only when you're collecting money, you don't have to pay VAT on the money. So the evidence that if I was monetized on YouTube, and if my channel wasn't taken down, also I wouldn't have to pay VAT. So what that is evidence of is specialization. It is evidence that the channel is exempt from paying VAT, so it must be a specialist channel branch, not treated normally like everyone else, which they're not creating. So it's evidence that the channel, by not having to pay VAT or tax because it's an online service, it's evidence that it isn't a normal channel like everyone else's. So if it's not a normal channel like everyone else's, then it's a special channel. And not only that, it's protected by Parliament, standing orders, and by the 1688 Bill of Rights. And some people say, well, what about Biden, you know, taking channels down or telling them to take channels down, or Parliament? Well, they can't. Their standing orders are published, fixed. Share this petition when it's for a petition. They can't censor it. And even if, the thing is, the local council, through the Town and Country Planning Act, you automatically get deemed an express consent through the Town and Country Planning Act to put stuff up through the use of the enactment, the 1688 Bill. The council aren't allowed to take it down. The council and police aren't allowed to do illegal canvassing and remove it. On that basis, as well as the council not being allowed to move it, Parliament can, even if they don't like it, because you're using the 1688 Bill, and they can stick their standing orders where the sun don't shine on their stupid petitions committee standards, because you've got a right to collect those signatures and lay the 100,000 signatures, whether they like what you're asking for or not. And this is the issue we've got with the Welsh Parliament at the moment, with that 20-mile-an-hour speed limit petition that's got over 400,000 signatures, which, you know, is eligible for a referendum. How many more signatures do you want? There's enough for the entire... It's matched 5% of all of Wales. So, I mean, the entire country of Wales. 5% of the entire nation of Wales. So, I mean, Secretary of State for Transport is taking the mickey out of us all. You know, and so is Neil Mohan. So on that basis now, I'm going to have to ask Robert F. Kennedy Jr. to do something about it without delay, because to none we will deny, to none we will delay right or justice. So Neil Mohan is going to have to do something, because regardless of what his policy is, my channel is got legal right, and it's electronic mail. YouTube's electronic mail. I've been given legal. Well, we've got it's enforcement, and really, what people should be doing, Parliament should be. If you really, there should be a form. There needs to be a form like in the High Court where you know, like Sabina form basically that you fill in to the House of Commons if your channel's been taken down, or if the newspaper won't publish your advert, or if Royal Mail refused to deliver your letters, for example, or if BT refused to, you cut your phone company off. This is when you're paying for it, by the way. Or like email. Really, also as well, Hotmail. Really, I mean, you shouldn't have a cap on daily Hotmail limits if you want to start collecting petition signatures. Although it's hard to get email lists now because there used to be these big email lists, but everyone's scared. We've all been terrified and scared by all the spam. So now no one can do that. I think the government have been shutting it down. I've got a feeling that. From the year 2000, 2005, when there was all phishing going on in emails, I just know that, all the people behind all those scams are the government, because they're the people who don't want people to make good use of those things. And then people, kind of like lock it down. They really want it locked down and not to use it, because otherwise, you can just get, people would be having referendums, local referendums, left, right, and centre, and the government wouldn't be able to have these overall plans and strategies, which they're desperate to do now, in order to maintain this security state, cyber future of their innovation and design in collaboration with these platforms. The law is meant to be there to keep the peace, and I've found that I've had nothing but distress from what's been happening around us from our local council, and also when it comes to this, probably should be in another video, but the council chamber, I'm going to throw this into this video. From the Magna Carta and the Petition of Right, that clause that's also in the Article the 6th in the First Amendment that says, you can't be deposed of your things without judgment of the peers. Well, the thing is, when you've got a right to object to the council and you get petition signatures, even 100 or 150 against like a building site, you're actually you're not leaving the councillors to decide it. The councillors, make a decision in the chamber. What you're doing is, if you actually bother to go to the public and get a petition and hand it in, you're going to the judgment of the peers. It's almost like the difference between having 3 magistrates or a jury. When you bother to go get a petition against a housing or building site, what you're really doing is you're getting the judgment of the peers. And really, unless someone else gets a petition in opposition to it, then you are making a judgment. And it doesn't have to be based on any rule of law, like there's 15 squirrels under threat in the forest or whatever. Which means that, according to Magna Carta, which is still in effect, that clause, that what the council have been doing is they haven't been making council planning decisions on the judgment of the peers. What they've been doing is they've been doing it on their own opinion, and they've been opinioning in the favour of corporate entities, which has allowed all the KFCs and McDonald's to explode, make a fortune for billionaires, and make us all health ill, and also, bye-bye Ponyfield, bye-bye countryside, hello noisy traffic, and people have been making a hell of a lot of profits out of these housing builds, banging industrial estates on roundabouts, and a lot of people have gone out of the way to protest against it. And what I think has happened is that the corporate entity has basically taken our rights away from us, and it's put money on the table in the council chamber, and we've been overridden because you don't have to be by rule of law. It doesn't have to be, the river's got 1,500 micrograms of carbon in it, and it's, Chris Packham, he's got his fucking car, get his little digi air pollution measurement out, and, there's, 15 litres of, creosote in the river, and 16 frogs have died, or whatever you want in great detail. This is what Robert F. Kennedy does in court. There's 1,500. This is Robert F. Kennedy. There's 500 millilitres of blah 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 chemical X in there, and 1,500 fish have died. This is Robert F. Kennedy's specialisation in court. But this is the thing. When you get into the petition, you get in the peers. And this is the thing. When a company puts planning permission in, it's only one company, one entity. It's one guy who owns the business, one person, one man. One man is saying, oh, guess what? I've got $1 billion. Oh, lucky for you. Where did you get that from? Well, I made profit out of it. I want to build, an airplane engine factory. Well, he's bringing a case to the council saying, oh, look, I've got these plans for an airplane factory. I'd like to build it. And the council say, okay, then, what's the case? Do we really need airplane engines? Is there a compelling case for them? How many flights are there? How many people are wanting on holiday? Where's all the figures? What's the need? Where's the need? Well, this is the thing. It's still one person bringing a case. At the end of the day, the judgment of the peers is that, what village is it affecting? Well, the village of the people who it's affecting. If you get a petitions, we don't want it. We don't want airplane engine factory. This is our village, right? That's it, done. We don't want it. Now if the person who owns the factory wants to go around the village and knock on doors and say, well, you signed my petition to get this factory built here, then he's welcome to do that. But he isn't. He isn't getting any signatures. What he's doing is slamming pound notes on the table, money, and he's saying, oh, I've got, £1 million. But you don't buy decisions in the council with money. You buy it with judgment of peers, right? And unfortunately, we've been fleeced because they've already done it. They've done us. They've done it to us. It's like your daughter getting, it's like your daughter having sex. It's done. There goes virginity. Boom. There's boom. And airplane factory. Boom. Done. We've done it. Boom. Chemicals in the river. Boom. New petrol station. It was like nice rustic petrol station. Boom. Where with a planning notice? They want a planning notice because you didn't put one up, but you just there was supposed to be a planning notice. Then there's another guy, I'm going to build a lot of houses there. A lot of people in the village objected to it. Well, how was he even building the houses? Well, I've got a lot of money. This is the thing. Sunak, unfortunately, sovereignty, pound notes, sovereignty. And what's happening in the council, when people in a town or village go out of the way to collect the judgment of the peers, it's not being counted. Well, it's been undermined. And they're saying, what the council are doing is they're saying, you can only complain on point A, point B, point C. Bollocks. What about Ian Bray? He's the jury. Well, there's no legal basis for this. Bollocks. We don't want it. We don't want Ian Bray prosecuted. Now, this is why, Vobes was saying that they used to have a jury in civil cases, and they kind of scrapped it. And we know why. Because, if you start having jury in civil cases, then that means that, the random people are deciding whether or not, Warburton gets to expand his factory or not. And Mr. Warburton can't have, a load of normal people, commoners, deciding whether or not he can expand the Warburton's factory or not, because they might say he can't. And then he's not, £1 billion Warburton. With power, he's got no power. It's like his workers have more power than him. And that's why they put a stop to it. Because really, what happens to Mr. Warburton with Warburton's factory is he's no longer a commoner anymore. He's no longer a normal member of the public. He's got money. He's got millions. He's got billions. So effectively, what the government regard him as one of them, one of the peers, one of the rich people, one of the billionaires. He's effectively a peer of rich people, built big businessmen, and peers of big businessmen can't have commoners, appearing in court, and making decisions, particularly when, what happens if he splits up with his wife and they've got to split the factory. Then you can't have a lot of, they would be disgusted with it, the commoners. Well, bloody hell, all these, what happens if you have these civil cases between, Warburton and his wife splitting up? You have a lot of jury, they might be disgusted that he's even got that much money in the first place, and they're even bickering over, getting the leg over with a supermodel or whatever. So, that I think that's why they probably put a stop to those juries in civil cases, because then what you get is MRR Buffnot and husband and PSYOPs 77th Brigade, Cameron and co, basically running the country, and their peers are then, you've got these key figures in judicial. Investors, possibly even, police chiefs invest in all these companies. They're taking judgment away from people. What happens in civil matters? So I think it probably was quite. We got fleeced out of that. Juries in civil proceedings as well. I think, because I know that they had them at one point. And what about YouTube? Who even votes about YouTube? I mean, really, how can YouTube have immunity? How can the US government have YouTube have immunity? That means that they're not liable to the public. It means they're not liable to judgment by peers. That means that YouTube, if they do something wrong, it means that it can't be decided by the public, the peers, which is kind of ridiculous, really, to think of it, to say that, it affects the people. If it affects all the users, it means that all the users don't have a say in a jury about YouTube, which that is quite concerning, really, which is, I think they've just had Zuckerberg up in front of, I know they've had Zuckerberg up in front of the senators. Was quite a lot of points I wouldn't mind doing a bit of a commentary on that. So I think that YouTube are breaking the law by removing channels that are political, and then also removing eligibility for monetization. Removing monetization eligibility. The thing is, I don't really want to monetize because I don't really want to have to force people to watch adverts, but I think they started making everyone watch adverts, even if the channels weren't monetized. I think they were still making people watch adverts at some point, although you never know because you don't really know. I don't know whether people are going to watch adverts or not when they watch my channel, although, I've still got another channel, but my other channel's got all the evidence on it. So I think YouTube have been breaking the tax law, because I know there'll be a lot of channels on there which are educational. So they'll fall under this. And there are religious channels as well. Churches have got channels. So they don't have to pay tax either if they're monetized. Now what they'll attempt, I don't think they can refuse to monetize them, because they're actually, out of all the type of channels you can have, they're the ones that are protected and also don't have to pay tax. But how YouTube are treating it is they're treating you worse. They're actually treating you the opposite. They're actually treating you as if you've got no rights or the least rights, and then they're not even monetizing you at all or anything. In fact, they're treating you the absolute reverse of what the law says. That they're treating you completely opposite from the law. So there's got to be some accountability there, and I don't think that it's enough, this Susan Wojcik stepping down and Neil Mohan going up there. I don't know what that's supposed to mean, but at the moment, I know that it's illegal. Robert F. Kennedy Jr. needs to do something about this, because I know that Standing Orders 145A of Parliament and directions to share by electronic mail means that my Petition channel has got a right to use electronic mail, enforceable by enactment and standing orders of House of Commons, to send, if I want to send Robert F. Kennedy Jr. or anyone an electronic message through YouTube. Comment is a message, electronic, then it's unlawfully been taken down. And there needs to be a form from House of Commons that you fill in, like, Sabina form, and then one of the 11 committee members signs it and send it into YouTube, and that's it. Put the channel back up now. That's effectively a court order, and they've got the power to do that. They've got powers because the powers are for function of sharing petitions. And if you can't share it, you haven't got any powers. That's why you got automatic deemed and express consent. You'd have to get consent from the council. I don't even know if you need to ask Parliament. I think there's a legal. I think it's immediately enforceable, because deemed and express consent is immediately enforceable. But if someone you get a court order, if someone's obstructing it, but really the police should do it because they're breaking the law. That's the thing, that they're breaking the law if they take it down. It's unlawful. It's like it's abridging the right, isn't it? So, really, all the police seem to be doing is taking things down. When there's, unless, it's not like sending the bailiffs around. Who enforces subpoenas anyway? There needs to be some sort of form or something. I've already compelled YouTube, because I've tied it in with something in the High Court that I'm doing, because I need to access the data, and they just ignored it. So, something needs to be done about it, because there is, the monetization. I know they've unlawfully removed monetization eligibility. On what grounds? I don't know. They don't tell you. This is the thing. They're taking legal actions and they're not informing you. If they are making a claim against you that you don't have a right to monetization, then they need to give details. Or how can you, make a counter claim if they don't give you any details? They're being very vague on purpose. I don't believe that there isn't full immunity for them, because their immunity is really only in copyright. They can't have immunity if they commit fraud. They haven't got immunity from breaking normal laws. They haven't got immunity from headbutting each other in headquarters, and they haven't got immunity for committing defraud. I tell you something, YouTube aren't immune from tax fraud. If YouTube commit tax fraud to IRS, they don't have immunity. So if they're issuing false statements to people, they can't have immunity. They can't have immunity, because that means they could just, lie to IRS. So if they lie to me or lie to IRS, what's the difference? They're issuing false statements. They're not covered for felony. They're not immune from felonies. They're immune from certain civil. They're immune from certain civil actions, particularly copyright. But they're not immune from felony. And fraud is a felony. It's not a civil matter. Fraud is crime. So if they're issuing fraudulent statements, it's crime. And the next video, I'm going to probably I'm going to have something to say about that Zuckerberg grilling that he got from the Senate as well, actually.